Please type your questions in the chat box, and if we cannot answer your questions in the given time, we'll get back to you through email. So if you can type your email with your question, that will be great. And today we are bringing in immigration experts to explore key topics shaping the legal immigration landscape. Every year, a large number of Indians come to America in pursuit of their American dream. As law-abiding, hardworking, first-generation immigrants, we have made this country our home away from home. However, navigating the immigration system is far from easy. This process is complex, wait times are long, and policies change frequently. Many of us are on temporary work visas like H-1B, O-1, H-4, J-1, J-2, and F-1, and we are facing uncertainty due to shifts in the leadership and evolving immigration policies. Even something as simple as going back to home to visit the family has become a challenge. We are in uncharted waters and we have many pressing questions. To help us navigate these issues, we are honored to have senior immigration attorney Praveen C. Medikundam with us today. Now I will request Amitabh to introduce our speaker to you.
It is our honor that Praveen is here today. Praveen is a partner at International Legal and Business Services Group. He holds a Master's of Law from Temple Law School in Philadelphia and is licensed to practice law in New York and US federal law. With extensive expertise in US immigration laws, corporate and international transactions, Praveen represents clients worldwide in immigration matters, corporate restructuring, mergers and acquisitions. He also has experience in federal and New York corporate law and holds corporate law admissions in both the United Kingdom and India. His deep understanding of immigration and corporate strategies makes him a valuable resource for our discussion today. Welcome, Praveen. How are you today?
Yeah, thank you. Thank you. Doing good. Hope everyone is good and you have recovered from Kansas City from the recent loss on the Super Bowl, I guess. So.
Oh no, don't.
Yeah, that is correct. Like we all were expecting a three-peat, but anyway, we can do that next year.
Definitely.
As we all know, Praveen, that there are a lot of immigration changes had been forecasted and had been applied also, I guess. So, what's new today? What's new in this 2025?
Thank you for introducing first Amitabh. Then I'm really honored. I am excited equally to join the Bengali Association, Kansas City, the Sangam. Very nice to share the knowledge and maybe clarify. Let's see if we can be helpful together in helping few people in clarifying and finding a path in the US for immigration. What's new? Yeah, everything looks new for immigration, right? Then when you are going through the newspapers, listening to the talk shows and everything, it's sometimes few things like in the immigration lawyer's perspective, I see few things exciting, especially for H-1Bs and work visas in one way. But at the same time, there's a lot of fear, a lot of things around. But honestly, nothing has changed much for the H-1Bs or the work permits in general, except that fact that maybe it was little lenient in the last few years. Now we are actually seeing more enforcement and getting into a stricter scrutiny of the rules that which probably most of you already know. But going through them, then learning how to navigate would be definitely important for all of us in this time. Because as Sonali rightly mentioned, a simple thing that you have to visit your family home is definitely challenging at this point because you need to make sure you have all the documents, then review them. Then you don't know what is hidden in that. Then you don't want to expose yourself at the port of entry or when you go for the visa, when you step out and just get caught in this legal maze. So with that, few things on immigration. You have heard about the birthright ordinance, which probably is now everything is clear that it's not into effect. It's not going to effect unless probably it goes to the Supreme Court, and we are all waiting how that goes. Then other than that, I think we'll go topic by topic on a H1B, on F1s, and what it takes for H4s and other things to understand what's really new. If that's what Amitabh meant, we'll go step by step. I think you are muted.
As one of the H1B holder, we are very much interested to know that is there any application process changed or the lottery process has been changed?
Right. So let's start with the lottery process. Maybe that's the starting point, which might be helpful for many audiences today. So the lottery remains the same. The selection process remains the same like last year, but the fees has increased. It used to be $10 per registration, which is supposed to be done by the employer. Now it is $215. Understandably, to cover the expenses, and also probably it discourages frivolous registrations. And you have seen many frivolous registrations in the past that people just register for the sake of it because they think that the opportunity is losing and the employer might not have plans to really recruit, but still register to see like if they get selected. And most of them don't even apply for the H1Bs, which affects genuine employees who are looking for H1B selections, genuine employers who wants to hire people who are already working for them on different other visa statuses maybe. So that would be the change this year for the $215 is the change. But again, if you have already noticed in the past year that they have implemented, the lottery is employee centric right now, rather than just going through multiple registrations. Each registrant would be identified with that unique number or unique identification number as their passport or something, then they would be selected. That means it's okay for people to be registered with multiple employers. It's not wrong, and that will not jeopardize your chances. It will allow you to choose an employer if you get selected in the lottery. So it will allow you to choose an employer to whom you have to go with based on the opportunities, based on different criteria that you might feel good, feel that it is beneficial. So it's okay for you all to understand that to do multiple registrations with different employers, because how many ever employers register you, it's just one person who is identified in the system. So when a person X is identified, he's selected in the lottery, then maybe 10 different companies might have put his name as per the registration paying $215. Then this person would actually be available for all these 10 employers to be hired. Then it becomes the employee's prerogative to select an employer who best fits into their criteria. So that's a good thing, which is already there. Again, that's been continuing right now. Those are the changes for the H1B. But again, if you dive into the H1Bs, I think there are four major changes. Not precisely because of the current administration, it's because of the past old administration, the Biden's administration before they left. They codified certain regulatory and agency rules which were already existing, but they make sure that these are all codified. That means they remain unless the current administration takes a procedure to change them, which is difficult, time consuming, which they might. But otherwise, as it stands today, the major changes that I can see for the H1B is the specialty occupation, right? So the specialty occupation was more narrowed to some extent, in my opinion, in the previous years, because it clearly said that the beneficiary should have a relevant degree to work on certain profession, and making more narrow for employers to explore. So, for example, if you have to hire someone as, say, a project manager, okay, then obviously the project manager, there is no definition what can be an underlying education for that, which actually opened up a lot of discussion with the USCIS that always we saw RFEs and stuff like that. But now the employer can define that the possible degrees that they can accept as a project manager. So there is little broader version of the whole thing, that there are other education, other degrees which can qualify for this profession. So that actually makes it good for us to represent cases on H1Bs especially employers trying to hire people from different degrees. For example, in computer field, as you all know, it's not just computer science. Somebody having a major in computer science would qualify, but people with other degrees might also qualify based on their experience, or sometimes it's related job duties, right? The related fields. So in that situation, it's easy to define. And as long as the employer has that broader scope of degrees that they accept normally for the profession, then it's good for us to do it. Then that goes to the second step. Then how does this affect the consulting? So consulting has to be, again, as we initially discussed in the opening statement, I said we had a bit of relaxed immigration procedures in the past few years, but now all these things have to be a little tightened up, and the current administration is more keen in implementing these policies. So that's the difference. So what that does mean? Then you will see increased RFEs, you will see increased scrutiny on every application. So the codified regulations now has said that you have to give advantage of previous approvals. If there is some approval which is already in place, then the USCIS would actually consider as a good, and then they try to implement the same thing, and maybe there's a better chance of you getting an approval. That is true. But if it goes into the consulting, as we were discussing, you need client letters. Then many times in the past few years, you got away getting approvals without client letters. Then, if you remember time during Obama administration, I believe we used to ask for specific client letter language to be presented. It's not just a specialty occupation, but even going further, defining the end date of the assignment that determines the outcome of the H-1B. That's going to be true again, most probably. So why? Because the codified regulation clearly mentions that when you are going for a third party consulting, it's allowed under the current rule. It is allowed for a H-1B employer to assign an employee to a client, but the specialty occupation has to be defined by that client. It's not by the employer who is assigning him to the work, because he's not creating the work. So now the client letter becomes more so important, and the language has to be more specific, defining that this job title or this position needs minimum of a bachelor's degree, and has to define what are the degrees that they would accept for this particular job title. So that would actually help us defend the H-1B petition. And of course, because the duration has to be going through that, then the duration has to be mentioned by that client, saying that this position is open for 3 years, 2 years, or with possible extensions. Then that's where probably we have to struggle a bit on the duration of the H-1B approvals, because in the past, you have seen in the last few years, there were always 3 years approval, and maybe people might have forgot that you used to get 1 year, 2 years, and sometimes 6 months approvals based on the language in the client letters. That might come back again. So that's one bad part. But in general, the employer-employee relationships and all those things remain the same. Then one exciting thing for me personally that I have seen, which really, when I discuss with students especially, I speak with many students who are really enthusiastic, entrepreneurial, very knowledgeable based on the current trends, the way that they attain degrees and knowledge. They want to have their own companies. That was not possible earlier. Then sadly, we always used to say again, in a way they used to allow, there was a procedure where we used to do H-1Bs for people who are more entrepreneurial, but it is much clearer right now that you can do self-sponsorship in a way. That means if there is a student who is on an OPT, then they want to actually create something. They are innovative, they are innovators, and they are entrepreneurial. You can incorporate your own company, hold majority, more than majority of the shares in the company. Then that company can sponsor you as their employee, as long as the position they offer you is the company, your own company offers you is a specialty occupation. That means somebody who is graduating in computer science can get a sponsorship from a company which they incorporated, he or she holds majority of the shares in the company, and then get a position sponsored by that company. That is more so true for some doctors, some lawyers, or maybe there is a dentist, right? So who have a license to practice, and then they want to start their own firm or own practice or own company, probably that's something that they can pursue at this point. This was not there earlier. So that's one part that's very new and which is really exciting for all of us. And again, that might even help some of the people who are very senior and they are actually working for this big multinational companies who are innovative, who actually have driven innovation in those big companies, but for whatever the reason, sadly now they got laid off, right? Then they have entrepreneurial ideas. They can incorporate a company. They can even avail this. It's not just for the students. Then you can always get the H1B approved from the company. The only rule, primarily what USCIS does is they give you an approval only for 18 months in those situations. And then they would allow you to go for a full extension of 3 years, just so that they want to see whether whatever the business plans you presented is true and whether that has materialized, whether you're working in the same thing, whatever you mentioned, to have checks and balances. That's what USCIS has adopted at this point. Again, these are all
Quick
the old administration. Yes, go ahead.
So will this go through the lottery process? I mean,
if someone is not selected in the H1B, they have to go through the lottery for sure. So for this H1B registration, then someone can incorporate a company, have a business plan in place, then hold majority shares in that company. As long as it is true that you have an innovative idea, that you can create something, provide a service or create a product or do something, then definitely you can do this. And you can this company can actually register. Now a company is different from the person, right? This is a basic rule of the corporate law. So the company can actually act that this person, even though he holds majority shares, then can do it. Otherwise we used to think that this used to be a conflict of interest, like, how can you incorporate a company then sponsor yourself, then it's a self-employment, so it's not allowed. But now the codified regulations clearly allow you to do it. So that's the beauty of it. And genuinely, and there is a sense or a discussion sometimes of fraud or abuse in that, but that's the reason you got it for 18 months. But as long as it's genuine, this is definitely something that people should pursue. I talk with companies, I talk with students especially. I feel so excited that there are entrepreneurs, there are people with genuine ideas, genuine development, genuine services. And I talk with doctors sometimes. Then they can go through this. So this is, which is really a nice thing.
Is there any added advantage to this, or any? I mean,
Yeah,
compared to the regular H1B?
right. The advantage is only that you can be your own employer, right? You can start your business, reap benefits out of it. It's not just employment. You don't just take salary, but you can also get the profits from the company. Not only that, you are allowed to manage the company. So the H1B entrepreneur rules allow this employee who sponsored himself to primarily work in the specialty occupation. So if someone got sponsored as a dentist for that particular company, then they have to primarily work as that. But they're allowed also to do some duties which are attached to ownership and management. So again, it's not that you cannot say that I cannot be doing. You're allowed to do it to some extent. But otherwise, primary job should be the specialty occupation. Then run the company, then employ. So this maybe USCI has thought based on the youngsters, based on all the innovation, or people even who are experienced, 15 years, 20 years, who are stuck with this green card process, might be able to actually create more employment in the US by contributing to the economy, by helping themselves and doing all these things. Such a wonderful thing.
Yeah, definitely, it's a very
So
good.
at this juncture, I want to say that the contact number of Praveen's company is 847-995-1515, and the company name is International Legal and Business Services Group, and his email is Praveen, Praveen @bizlegalservices.com. It's the chat box, bizlegalservices.com. Thank you, Praveen, for this. And we are already getting a lot of questions. And one of them is Pallab Ray has questioned that, what is the conversion process from H4 to F1?
H4 to F1, then while you are in a valid H4 status, then you should always get an I-20 with a start date, with a sooner start date, and then file for I-539, which is the form that we use for change of status. Then include documentation. Again, three things that you have to be aware of when you're doing this H4 to F1 change of status. F1 being a non-immigrant visa, and the intention should be for the person who's seeking the F1 to complete their studies and go back to their home country. So if that is what you are trying to do, then three things become very important for you to prove. Number one, the purpose of your change of status from H4 to F1. So usually we try to include a statement of purpose, why you are doing this, and what is the reason for your change, requesting for the change of status. And the second thing is, if you are in the US already, then how are you going to manage your finances? That how is that you're going to pay the fees and living expenses? Then there should be documentation to prove that you have sufficient funds to pay the fees and bear the living expenses. Then third important thing is you should not be, I know most of these people on non-immigrant visas, especially on a H4, H1, they might be staying in the US for more than few years, or sometimes even I have seen people staying for more than a decade now, still on a H4. So then it becomes more important when you go to a non-immigrant visa like F1 to prove that you have not abandoned your home country. That's one of the requirements, because this is an F1 visa that you have to prove that you have connections, strong ties to your home country. Then you need to present evidences that you have not abandoned your residence abroad, probably including government identifications, then bank statements from India, then your extended family or your immediate family in India, then your properties in India if you have. Those are important for you to prove that you have that intention to go back. So this becomes important for that. And
Okay,
in
thank you
that
so much.
context, in the current scenario, we have seen a lot of people getting laid off. So someone on a H1B gets laid off, and maybe their derivative beneficiaries on the H4, right? So they continue to be on a H4 for the 60 days after the H1B employee gets laid off. So the benefit of the 60 days grace period would also apply to the H4. But you can actually change your status within that 60-day period to F1. So that's one thing available. Then you can also opt for premium processing if you find a program, a course which starts immediately, not like earlier where you have to file it and then sometimes it used to take a year to get a change of status approved. Then deferring your admission for the next one semester or two semesters I've seen, but that is not required right now because you have an option of premium processing for some people who are doing an F1.
Yeah, I have one specific question. So my son is already in college with H4 visa, H4, and he will be like 19 on month of May this year. Sorry. Yeah, so what is the best time to convert from H4 to F1?
Right. Probably this is the right time to consider changing the status from H4 to F1. There are advantages and disadvantages.
Mhm.
It all depends on the university that he is in and how they treat this. Because I have seen some universities, as long as the student has graduated, has completed his high school, his or her high school in the US, then now going to the college on H4, they have always applied in-state tuition fees, right? There are some colleges which has a policy that way, which is surprising. Then they have continued to do that even after filing their fund. But if in your state, the university, if they are actually charging in state, then you actually change their status to H4 to F1, probably that might have an impact. You need to check that if they actually apply the international fees or out of state fees.
Okay.
But otherwise, the advantage that I see a person being on F1, they will be allowed to work. On a H4, they are not allowed to work. But on a H4, on a F1, they will be allowed to work. And primarily, they're allowed to work for 20 hours and maybe more in summer and certain occasions when the DSO recommends and when the program recommends that you can even work more, 40 hours, maybe in summer, or sometimes you are eligible for internships. And those kind of things might be beneficial for the student. So,
but it should be in campus, right? Not
the
outside.
20 hours is in campus, obviously. then of course there are options for CPTs in some of the occasions, as long as the program has been curved that way that they offer employment as a benefit, and probably you can pursue those.
Okay. So I can ask university that I-120 anytime, or is there any some like a
Yes,
time?
yeah, I think you can just check with the school. Usually at the beginning of the semesters is when they do this. But
Okay.
already in a program and he's already into the university in a different status, I think they should allow them to issue and change his status. But usually at the beginning of the programs is when you should opt for, would be more beneficial.
Okay. Last question. Do you help on that, like for H4 to F1?
Always we do it, and again, so surprising that some of the students, they don't know that they have to go through this process, because most probably they came here when they were toddlers, 1 year, 2 years, 3 years, and they went to high school all along, and now they are into the university. They realize that they are on a H4, and they don't have pretty much no idea about their home country. And
Exactly.
yeah, sometimes it's important that they have to go outside the country for the visa stamping and come back, because either they are visiting their grandparents or something, there is a celebration or an occasion in the family. Then they get really worried if the student goes outside the country having no connection, because the parents and the brother might have been a US citizen, he's born after him here in the US, then they've been just living in the country for more than 16 years, 15 years now, right?
Yeah.
So then how would you
Same
prove
here.
that you have strong ties to India? Then that becomes a major challenge, especially the father has been working here for last 10, 15 years, and the mother is here and probably even she working. So
Yeah,
definitely,
actually, Pallav, we were in the same boat and Praveen helped us with that.
Okay.
Yeah,
Okay. Thank you.
yeah.
Yeah, I will contact you, Mr. Praveen.
Thank you, Pallav, for your question.
Yes.
Praveen, I have a question on the topic you discussed before, like H1B filing through entrepreneurship. So, like in EB5, you have a minimum investment requirement. Uh, does this also require a minimum investment?
luckily, no, there is nothing like that. But the caveat is, when you have a company sponsoring yourself, then obviously you need to have, the company should have money to pay for these expenses, right? Now you're talking about a product or a service, then do you have enough equipment or resources to actually do this? Okay, I cannot just simply out of the thin air say that I will do a legal practice, then I have to incorporate a company and do this, I have a license. Probably you need certain tools. Then it's the same thing for an engineer, a mechanical engineer, civil engineer, then a computer science engineer. Then for any professional that they're, if they are actually doing this, they need to show that they have enough resources, and that enough resources has to be defined by the business. And you cannot undercut, you cannot present something which will make your chances less, which will become difficult to convince USCIs, right? So money becomes an important part, but not like an EB5 that I need 800,000 or $1,050,000 to invest. But it has to go along with your business plan, justifying everything. Only then you'll see an approval. So it has to be a very serious, well-rounded effort to get this into a H1B entrepreneurship. It's not like as a stopgap or something that you do it. Most probably it will fail, and especially the way that administration is scrutinizing these things, then it becomes very difficult.
Thank you.
If the case is strong, if there any better chance to get picked up in the lottery process?
There is no preference for that as such.
Okay.
There's no preference.
Okay.
Okay, Saurabh, could you please go for the next question?
So here
Vidyadhar?
is another question is here. What are the eligible sources of funds for an EB5 visa, including the use of loans, funding from an existing business in India for setting up operations in the USA, and other permissible sources? So this question is asking from Vidyadhar.
Yeah. Hi, Vidyadhar. So for the EB5, the possible sources of funds, let me just define and put it in one word or like one phrase. It has to be your own money. So what is your own money? So it could be a loan money, but again, it is based on some collateral. You have business or you have a property either in the US or abroad. then maybe you are loaning against that. So that property is at risk when you don't repay the loan, which no problem for the USCIS. So as long as the money is properly channeled through you and you are responsible, that is your own money. That can include a gifted money. Sometimes your parents, your brothers can gift you, because why would they give any gift probably by end of the life or whatever? Then maybe it's useful for you. Then somebody might think that it is better to give you at this point, which might be useful for you and your family. Then a gift is allowed as long as it's documented properly, and if there are any taxes associated with that money, and you have evidences for that. So those are the broad things, the sources of funds that you can have, including your own savings and any profits that you have gained in your business abroad. And as long as they are paid as a portion of drawings or dividends, and you have documentation and evidence to prove and it is tax paid, then obviously that can be used for EB5 investments.
Thank you, Praveen. That helps a lot. And does that include, for example, I have an existing business back in India, and it so it's an IT service business, and if that business itself wants to set up a company, a sister concern company here in US, and if the business has enough services and work that it can extend a little line of credit from bank and then use that money to invest here, and does that would it be an company investment, or would it be still, can I tie up myself with that and get set up a company here
It
with the
has to
same
be
name
your own
branding?
money. Company is
Right,
different from the individual. So the
right,
company money is not your money, but the company can pay you the profits. You can draw your dividends. You can take
right.
your money out of it. Maybe just sell your shares to someone and they pay you. That's
Got
a
it.
that money belongs to you. Then you can invest.
Understood. Understood. That helps. Thank you, bro.
Next question, please, Saurabh.
Yeah, next question from Mita. So she's asking, can a person apply to another state for a job when the H1B visa has been petitioned by a different state? And how to change the H1B sponsorship between two states?
Right. So again, employer remains the same, I'm assuming, right? There is only one employer. Then you are working in, say, Kansas right now. Then you get a job in Chicago. So how would you change state is your question. So what it means is, if there is any material change, you have to file an amendment. The employer will find an amendment. What is a material change? So material change is something which was initially presented in the H1B petition to get your approval for the employment. That includes your salary, your job title, your work location, and maybe in the third party consulting, where you're working for a consulting company, IT consulting company, and they place you at the client side, and the client has changed. So even though there is sometimes surprising that there is no change in the work location, because it's all work from home these days, it's pretty common. So assuming that you are in Atlanta, then your company is in Kansas, then your client is in California, but your company would place you in that client California's assignment, and you are working out of your home in Atlanta. Then the project ends and you end up getting a project in Texas. Now there is a client in Texas who is actually offering you this assignment. Then your company in Kansas would go and sign that contract, and he's assigning you to that particular new client. Then that still needs an amendment, because there is a change of client. So anything, if there is a change of client, change of work location, change of the job title, change of job duties, sometimes radically changing, then change of salary sometimes, even if it is more. So usually if you fall under a different category, then that needs, it's called a material change, and that needs an amendment. If that answers your question, I think if that's how I understood. Maybe if it's not, then you can rephrase your question, then I'll answer. Change of state needs an amendment.
I have a question here about the Dropbox eligibility for H1B and also F1 students who are traveling to India.
Right. This is a little sad, which is not so welcoming change that we are seeing right now. So the earlier administration said that you can go for the drop box as long as you had a visa approval in the last 4 years. So that's probably also because the nature of visa appointments and the way that the whole thing was going after the COVID, people were finding it very difficult to find appointments. Then to ease out that, they said that, okay, if a person has already gone for a visa and holds a visa in the last 4 years, their documentation information has been checked and he's going for the same category of visa appointment, then rather they just do the drop box. So that way we don't have to physically interview him. Rather, we do the background work and then give an approval. And that was more effective and really convenient even for people who are traveling with less stress in have to appear for the visa interview. But now they have made it as 1 year. So if your visa was valid in the last 1 year is when you will be eligible for the drop visa. And we haven't seen that getting implemented right away. Maybe any appointments starting now will have to see that. But we have noticed that in the appointments which have been taken on Thursday also qualified for drop visa, even though the visa was in the last 4 years. So now this is the new change that you will see that people with that kind of situation might have to appear for the visa, putting them at more risk. And in that context, I will also add anyone who is traveling on a H1B or even F1, just you have to be holding those documents. Make sure, review all the things, including the LCA amounts, whether all the conditions of your LCA, including the money, the salary, and including the work locations, job titles, job duties, everything aligned, and for sure carry the client letters. And one advice would be when you go for the visa stamping, even though you have a client letter, we see a lot of 221Gs. The only for the fact that I understood based on my experience that the consular officer would not be confident that you will still have a job when you go back. See, you might have a client letter which was issued probably on, say, February 1st. Now, today, I'm sitting in front of you. If you're the visa officer, I gave you that letter saying that this is my client letter and which is dated February 1st. Then my question would be, would this job be available when you go back on March 1st, right? So that is the reason they issue a 221G. And that means they will find some time to actually go and verify with the employer whether this job is still available and whether the letter they submitted is genuine. So yes, most of the times it's for the genuinity, but also if whoever is traveling and can carry a client letter which clearly mentions that the employer knows that you are on a vacation and you are expected to return back on this time, gives me a little bit more assurance than a blank client letter, right? So that says, okay, the client is aware of it, there is an arrangement, and it gives you some kind of an assurance that he has a job available when he goes back. That makes a big difference. So when an visa officer is reviewing it, that gives him a bit more assurance for him to issue. Because in my experience, I have always seen all the USCIS officers or all the consular officers are pro immigration. They want to actually help you. Okay, this program is meant for that. They want to do their job. They want to approve the visas. But would they have relevant documentation in hand for them to put their signature, put their approval on that file is a question. So by taking all these proactive measures, you can really help the visa officer to make a decision saying that, hey, he has a client letter which clearly now validates and says that he has a job available when he goes back and a vacation has been even determined, right? So to some extent it might help. But again, if they want to verify the authenticity of the program of the client letter, then obviously they will go and do it. And even for that, if you can actually provide more authentic information about the company, about the assignment, including the name of the person who is signing, their contact details, or any other details, which makes it easy for them to know that this is a bona fide client letter, will actually avoid the 221Gs. Most of the situations I have seen that we have implemented that for the clients, then they could actually get away with that.
So,
And here comes here comes the experience. And friends, believe me, this firm has a lot of experience. They are helping a lot of people. Please contact Praveen at bizlegalservices.com. If you have any other questions by email, they can contact on the phone number 847-995-1515. So Saurabh, I would like to request you to go for the next question.
So
Yes.
next question is from Soma Chakrabarti. So she is asking, she has got just her green card this week and she wants to visit her family in India next week. So please let her know if she needs to get a visa for her travel to India. She is not able to get any clear answer from the internet.
No, you have your green card. I'm assuming that you already have the green card in hand. So, with your passport, valid passport, and the green card, you should just simply travel and you're absolutely fine. Then, again, nature of the petition which helped you get the green card also matters. If it is employment based, family based, and have those relevant answers, if at all asked at the port of entry. Okay, for an employment based, then be ready to verify that you've been working for this employer and you continue to work for this employer if they wanted to double check or verify. And any contradicting answers would jeopardize. But otherwise, you are a green card holder, you are a permanent resident, you have a green card in hand, then there is no problem at all for you to travel. Travel with ease.
Thank you. Thank you.
Okay, I think one question was there for from Dr. Animas Dhar is that he was concerned about the F1 visa holders, especially at the time of OPT. I think there are some buzz going on that those who are working in a deep research or something, they will be eligible for OPT extension. So is there anything going on in OPT, Praveen?
Right. There is nothing new with the OPT except for the fact that the current administration is doing more scrutiny of all the visas, including OPT. So whoever is on an OPT is supposed to actually report to the school that they are employed within 30 days, right? Within 90 days. So they cannot be unemployed for more than 90 days. So that's one thing that you have to be aware of it and make sure that you provide a bona fide valid OPT letters. And this information, for whatever the reason, just like the H1B site visits, we have recently seen site visits for OPT also for various reasons. An employer would be asked to give the list of all OPT employees currently under training with them and including their work itineraries, task reports, and everything. And if they are getting paid or not paid, and even they physically want to verify if these people really exist. So do not actually go and take letters from employers just as a placeholders because that's not right. Okay. If you are actually on an OPT, you are supposed to, that's a rule that you're supposed to be working, getting trained by an employer. And the only grace period that you have is 90 days so that you can be unemployed during that time. But otherwise, the rest of the period you have to be employed. Again, to some extent, the law allows you to be unpaid during the first OPT, which is the 12 months OPT, where it can be an unpaid internship. But very surprisingly, universities are now rejecting OPT employment letters without mention of the salary, which they're not supposed to. We always talk with those universities, explain them, educate them, because there might be some positions, honestly, they're not paid, right? So, because even I have seen big multinational companies, sometimes they offer limited programs which actually do this kind of things, saying that it's an unpaid internship uh, because the company would end up actually providing a lot of resources, spending a lot of money and things from their end, and they think that they would actually provide unpaid internships. So in the first 1 year, it's allowed as per law, then but otherwise it has to be bona fide. And people actually doing this without bona fide intent are in trouble, and people are even traveling on this kind of situations, and most of them are getting deported from the port of entries. So never do that. Don't actually travel unless you have a bona fide employment here and have relevant letters to justify that and truly get trained is the answer. So I always tell people again, immigration is a maze and it's complex. And Sonali's opening statements were very clear, saying that hey, this is very complex and with all this news coming up and we don't know, even though we are just navigating this since last many years, pretty much everyone is an immigration expert through their own journeys, but still is confusing. Very simple. Always remember this. Uh, get the right advice. That's what we have. Our motive is to give the right advice. So get the right advice always. And one thing to remember, there is no right way of doing a wrong thing, unfortunately. So people tend to actually do wrong things, and they always try to find the right way of doing it. No, there is no right way of doing a wrong thing. If it is a wrong thing, it's a wrong thing. uh, you cannot just do that, right? So do understand what is correct and what is not, and just follow the rule of law and take an advice wherever it is, whoever it is. Your school has a lot of resources, then your employer might have a lot of resources, immigration lawyers, then experience. Try to take advice, and it should not really matter, because we spend a lot of time, lot of resources in different things. This is critical. So, and it should not be that difficult for you to take an advice and plan your things.
Okay, Saurabh, please go to
Thank
the next
you.
question.
Explaining this problem. Thank you.
Okay, so next questions from Kajal. So she completed her general nursing in India, and she has a 4-year experience. Also, she passed NCLEX RN exam in US. So she is eligible for H1B, and now she is in F1 visa. So maybe she's asking for changing her visa from F1 to H1B.
Right. So there are specific jobs in nursing which qualifies for H1B. So because not all nurses would need a bachelor's degree, that's a well-known fact. But there are certain professions that she probably knows better than all of us. That which there are positions which needs as a minimum entry as a bachelor's degree, and we can always file H1B for those kind of positions. But still, that has to go through the lottery, unless the position is with a university or a hospital which is affiliated with a non-profit university, and part of it and all, that's an exempt H1B. But in general, the H1B program applies, and you have to go through the lottery.
Next question, please.
Next question from Rajarsi. So she is in academic institution and renewal of H1 in coming up. Has there any indication that the process time has increased?
Yeah. So we have already noticed delays in getting the receipts to start with. So we used to get receipts probably within a week, 10 days earlier. Now it's taking a little longer. Then the same thing, if someone gets a H4 EAD approved, then we are seeing that the H4 approvals of the H4 EAD approval, the EAD cards getting delayed for delivered. Again, not insanely delayed, but at least it's taking few weeks, 10 to 20 days to receive those cards in the mail. That also includes the H1B processing. So it might take more than 7-8 months. Now, in my firm, I have noticed there are petitions which are pending for more than 7-8 months right now. Earlier, 6-7 months, probably around that time, we used to see approvals. And in fact, after introducing the online submission of the H1B petitions, we have seen faster approvals. But I guess going further, we have to expect delays based on the resources that USCIS will be deployed, and maybe with all the shuffling that all the federal employees has to go back to work, and then maybe their work arrangements, and all those things have to be changed a bit, and expect delays. And especially if there are layoffs going on in all federal jobs, that might also impact. So considering the current administration's priorities, what they're going to fix, what they're going to achieve, definitely the processing times, we are anticipating that it would be.
In case of premium processing, the time remains same, right?
Yeah, the time remains the same for premium processing. 15 days, 15 calendar days.
Is there rejection rate more in premium processing right now?
Right. So yes, that's a good question. It's a general myth for all of us to think, okay, you go in a normal process, maybe there is a better chance of getting an approval versus going through a premium, might get more RFEs. Nothing like that. But again, mind you, to remind that you're paying more fees for the USCIS officer to spend time and try to give a decision faster. And without having that conclusive documentation, they cannot really do anything. Rather, if I'm the officer, I would end up giving an RFE, because I see that there are missing links or missing documentation, which does not give me a complete picture about what you are asking. Then better I give an RFE. Versus if I'm going in the normal process, maybe I have more time to dig through, right? Because I'm not pushed for the time. then instead of spending few hours, maybe I can spend few days and maybe figure out and find a link. Okay, this is what they're trying to do. I found this particular language in this particular contract which supports this specialty occupation, so hence approved. Versus I'm just rushed for time, and obviously that will to get more clarity, I would issue an RFE. It might be possible in my experience that I have seen. But otherwise, it's not that you file in premium, you get an RFE. If it is a case with all the documentation, stronger evidences, then definitely go with the premium. There's no problem. You get an approval.
And that's why I saw that in your firm your lawyers always try to get as more as possible in the paperwork. There is no harm to give more than expected.
That is right.
So
And
yeah.
yeah, that actually takes a lot of time going back and forth between us. But in general, the policy should be for everyone doing any immigration work to take time in spending, putting the documents and evidences together rather than, again, you are under rush because if they issue an RFE, sometimes they give you 30 days, then 90 days, then you are just now pushed for the time saying that you have to complete this within that time, right? So rather you putting yourself, it's a good strategy to actually go back and forth, spend considerable time here, and then give the petition to them. So there's no room for error.
And they have increased the processing fees for premium, right?
Right. It's 2,805 right now.
So it's already 4. We have few more questions on in the chat box. Would you mind, Praveen, if we just go forward with that?
Yes, no problem.
Okay. So next question is from Hemant Kandlur, that I'm on green card since 2013 and currently current validity till 2033. Considering the current situation in the country, are there any risks for continuing on GC which would be mitigated by naturalization?
Right. So can you again repeat the question, Sonali?
Okay. So I am on green card since 2013 and current validity till 2033.
Sure.
Considering the current situation in the country, are there any risks for continuing on GC which would be mitigated by naturalization?
Very nice. It's a very good question. And in fact, that encourages me to explain you about the changes in the family-based immigration, if at all. So we are always encouraging people to actually file for their citizenship for the one reason, because GC has its own disadvantages. Number one, that you have to be resident of this country all the time. For whatever the reason, God forbidden, you are just stuck with something outside the US for more than 6 months, a year, then that might jeopardize your residence, right? So rather, if you are a citizen, then that might be easy for you to mitigate. That's one advantage of moving to the citizenship. Then there are certain offenses or crimes, then invariably it might happen, or whatever the reason, then we cannot defend on people who are on a green card. They are still deportable. So if you are a citizen, then probably it's another way of looking at for the immigration. So it's always better to actually apply for citizenship for that reason, because citizenship is going to be hard based on the current approach that we have seen in the administration, because they want to make it really difficult, really rare for people to have a citizenship. It cannot be just thing to throw. Otherwise, they want to make it as a very valuable gift for people. So if you have spent considerable time here, then rather you just take the opportunity to file the citizenship. So in this context, I want to just introduce, it helps even employment-based, then also family-based, what is going to be in future, right? So the current administration, as it goes, then we haven't seen any major differences for employment-based for students, or we have not seen an indication that STEM OPT will be taken out or a H4 EAD will be taken out so far. And very fortunately, then the current president also says that he's pro H1B, pro employment based immigration, right? So that actually gives you a lot of ease that this might stay, hopefully. Then what happens then? How does the new administration wants to tackle immigration going forward? There are certain indications. Again, it's all my talk today is more based on my opinion, my personal opinion, and what I anticipate to happen. Probably more motivated, right? So just like how parents assume that, okay, my child has to become a professional, maybe a doctor or engineer or an artist or something, That way, as an immigration lawyer, I anticipate a comprehensive immigration, which there is an indication which might happen that they have to take care of it to address the current issues. There might be a overall getting a new immigration bill introduced, which might address a lot of things. Probably, if the current administration chooses to change it to point-based system. So currently, we are going through employment-based sponsorship through labor certification, I-140 and 485, which is all clogged up. Then rather go with the point-based system like Canada or any other countries, then they have different criteria under that. For example, someone has an age between 27 and 31 gets more points versus somebody who is 35 or 23. Because that's what probably they figured out that is advantageous to the economy or country. So they give more points. And in the criteria for the education, someone having a PhD from a US degree, a US university, would have more points rather than just compared to someone who is coming as a PhD from a different country. So you stand at advantage in that. And the US masters would have an advantage versus a master's degree from India or some other countries. So you get more points in that criteria. And when we sum up all these things, and English proficiency is one criteria, then job offer is one criteria, you'll get some points. So somebody has a job offer with 300% of the median wages of that particular city, state would actually get more points versus somebody who has only 200% more wages. So all this summing up, you are required to get, say, 30 points to file for the immigration yourself. Then you don't need any sponsorship. Then you apply for the immigration. Then whoever in the pool of those 30 points, the people who got 30 points, the administration might pick people who have more points. That means if you have 34 points, somebody has 32 points, then I have, like, say, 31 points, maybe 34 points. A person with 34 points would get an invitation to apply for the immigration. That's where your whole journey starts. So that might be a future of it, probably, right? So if that is the case, then students who are here, then they always tend to go with the second masters for whatever the reason. If they are not selected in the H1B, or then they want to get more skills and spend their time at the university, then prefer going with the PhD, okay? Because that might help you in the future. So that might be coming. Then they want to curtail, the current administration want to curtail certain immigrant petitions, which probably would be more beneficial towards employment. For example, they want to actually stop US citizens sponsoring their siblings, right? So if you are a US citizen, then you have your siblings, then probably take an opportunity, file for them, even though it looks like it's taking 18 years for them to get the green card, but still we don't know if those numbers will actually move and they might get an advantage. But otherwise, you will not have a chance to file this again if this bill comes into force. So filing citizenship, filing for siblings is really important for all of you. Then employment based. What happens to employment based who are already in queue right now? I have an EB3 or a EB2 priority date of, say, 2016. What is my fate? So then probably what happens in the immigration bill they introduce, this is just my opinion, that they might actually provide a solution for existing visas, because there is no way you can resolve it with the existing immigration laws that we have in the country, because that just really stays like that. So they need to find a solution for that to clear up, because if they say that we are only giving 140,000 visas, immigrant visas, that those are all point-based system, then what happens to these green cards which will overlap on the 140,000, which deceive their purpose, right? So this has to be solved at some point. And then how will that be solved? So probably there might be something which addresses this issue in the current immigration bill, saying that the current petitions which are pending, the I-140s which are pending, would be dealt in certain way. Okay, so maybe they might say that we will not count on the derivative beneficiaries, but we'll only count on those actual numbers, right? So that might actually give you more numbers. Then probably it might take few years for you to do it, but it might be. I'm just saying there might be a solution for existing problem. When there is a new water coming, the old water has to be absorbed some way, somehow, right? We cannot flush. So that's something good, positive that I see. Again, it's more my opinion, my anticipation, just like how we all think. But again, I've been positive since more than a decade, more than few years. but nothing was really happening. But good things happened in some administrations, that we got H4 EAD, we got OPT extensions, then we got DACA. Then this is the time probably they might also want to resolve this. Okay, they will resolve this once they clean up the system. That's what you see, how hard they are going on immigration, which is good. So survive and do the right things, take the right advice. Then just remember, there is no right way of doing a wrong thing. As long as you are doing a right thing, taking a right advice, following the rule of law, then there are good days to come.
Very well said, Praveen. Let's go ahead with the few questions quickly. Next question is from Adhish, and he's saying that he is currently on H1B currently with employer A, example, valid until till 2027. Now, suppose he got a new job with a new employer B, and they file H1B, but that got rejected. Can he still work with employer A with
Right.
current H1B?
Right, true. So if he has not stopped working for employer A, then it was only a H1B opportunity with employer B. Usually employees make the choice for that reason. They will not put down their papers with the current employer unless the other petition gets approved. So if that is the situation, then yes, you can continue working on the current application. There's no problem with that. But anticipating that, okay, you will get an approval, you gave papers here, you put down, then there is no employment with employer A, then you move to employer B, you started working for employer B, then you jeopardize your immigration. Then you cannot do anything about it. You have to just now get a new petition, or even you want to go back to employer A, I would strongly recommend you to go outside the country for the visa stamping if you don't have, or otherwise come back and join employer A. You cannot just assume and then come back to employer A, because you have already ended your employment with employer A. So
Okay,
that
the next question.
She is asking about her mother when reached at airport in India, and she came to know that her visa is revoked and she cannot travel. What should she do now? Wait for some day, or like reapplying for the new visa?
Right. It's unfortunate that maybe there was no notice of the revocation for whatever the reason, or sometimes even there are cases where the CBP is actually doing that by sending them back and forcing the people to withdraw their visas. Maybe they found something which is contradicting their visa status. So the only solution would be to reapply for the visa. There is no problem reapplying the visa, but again, based on the circumstances, definitely I can help you. We have helped many people doing that. But there might be a reason why it was revoked. Then you need to overcome those reasons why the revocation was enforced first. Then try to prove that it's a relevant visa for them. And if it is a B1, B2 non-immigrant visa, then you have to prove that you have strong ties to India, then you will go back and there was no fraud to start with. Because if there was fraud, if there was misrepresentation, then the consulate tends to actually ban you for traveling in future.
So anything changed in H4 extension process? There's another questions.
Right. There is no change as such. It can be actually applied along with the H1 or otherwise. Okay, one important thing that I realized talking with the client, which I think it's beneficial for me to share with all of you, that you can always file for the H4. For example, husband is on the H1, wife is on also H1. Then husband's H1B has expired and they have filed for an extension. Employer A has filed for an extension. Then, for whatever the reason, the wife's employment ended. Then the H4 beneficiary was in impression that she cannot file for the H4 unless the H1 is approved for the husband. No, while the H1 extension is pending, based on the receipt, you can also file for the H4. So then, for whatever the reason, there was a delay in filing. She was out of status. Then we are trying to fix it now.
Okay.
Very good answer. I have something to ask you. That is there any changes in H4 H4 EAD renewal? The grace period has changed from 580 to lesser days.
That's right. So again, there is no practical impact of that, I believe, unless again the H1B extensions take longer period, which was not. Then you have an option of premium processing as well. But yes, that has been reduced to 180 days. That means if your current H1 expired and you have filed for H1 extension, you are allowed to work for 180 days. That means you have to get your approval within 180 days.
Okay, next question, Saurabh.
Is
There's
there
a question from Kishola.
yeah,
So
is
just
there
going
any
back to just going back to that how can you mitigate that situation? Because it's just 180 days, and as I said, the processing time is 7 months, right? But remember, you are allowed to file for an extension 6 months prior to the expiry. So if your H1 is expiring in December, then you will file for the extension in June. Then you are allowed to continue working beyond December for 180 days, right? So you're talking about 1 year where the approval comes within 7 or 8 months. Even it takes 9, 10 months, then you're still in a better situation. So there are ways to mitigate, and probably that's what they want you to do. Okay. You cannot just file in the last minute and then prolong this because there is an opportunity for fraud and other things. If you don't have a job, you have just an H1B extension, you're continuing to work for 540 days. Just imagine, like it's more than a year.
Mhm.
Okay, so next question from Kishala, is there any specific enhanced scrutiny process implemented for fresh H4 EAD application? If the EAD is yet to be approved, is it advised to travel out of country?
Right. Well, different situations. Again, if you have a H4 petition approved, the underlying H4 is valid, then having a H4 EAD, you will continue to work and you can travel. Then if you have a visa, you'll travel back on a H4 or go for the visa and come back. But the H4 has expired. Then you have filed for the extension. Then you applied a H4 EAD along with the H4, assuming. Then now you decided to travel outside the country. That means the H4 might get approved because this is not a change of status. This is extension. So when you even go back to the stamping, then you come back, H4 EAD might get approved. Okay. But in the given situations, uh, exercise caution, then take advice, see what is your particular situation, whether this is something that will jeopardize your H4 or H4 EAD, then travel. Because there is no general rule which we can summarize and say which might be misguiding people because there are different situations in that. But the high level approach should be if you are on a H4, then your H4 EAD is applied for the extension, then you are going outside the country and getting back, then the H4 EAD still continues to be processed. Then, but you coming back, you need to make sure that you have a visa or going for the visa and come back. Then, if you are actually filing for H4 and H4 EAD extension, then now you want to go outside the country. Then the common question is whether my H4 gets abandoned. Then probably no, because you are filing for the extension, not the change of status. If it is change of status, it will be abandoned for sure. So then when you come back, see, when you applied, you are on a H4. When you applied the H4 EAD, you are on a H4 status. Then when you're coming back, you are on a H4 EAD status. So we have always seen H4 EAD getting approved even when you have traveled during that situation. But again, this is just something which has changes on a case by case basis. So just make sure that you get proper advice.
Okay, so next question is H1B stamping still happening in Mexico or Canada?
Right, good question. Yes, it's still happening, but these are ever changing. Okay, they just change every month, and the guidelines, just like how you saw the drop visa. So the best way is to go to their websites, the U.S. consulate website in that particular country where you want to go for the stamping. Check on the guidelines. They have always published these guidelines, and very surprising, and which most of you probably don't know, that these consulates are very proactive in responding to your questions. So if you send an email giving your scenario and asking if you can go for the visa stamping, they might reply.
Good to know.
So now, so this is our last question in our chat box. So does H4EAD receipt notice allow to start work?
Very good question. So no, per se, because why? See, a person who is on OPT is allowed to work on an OPT extension when there is a receipt. Why? Because there's an underlying F1 still valid, right? They are on a F1 I-20 still valid. They are registered in the school as an OPT and they have an I-20. So the extension is allowed and you can work on the receipt. Then an EAD which comes through a green card, which is I-485, when you file for an extension, When the current EAD expired, you can continue working because the underlying 485 is still valid. It is still pending. But what happens in the H4? The underlying H4 has already expired, right? Most probably. So you cannot continue working on the H4 EAD receipt. That's the reason. But there are specific situation exceptions where the H4 is valid until 2026 for whatever the reason. Maybe they went outside the country and re-entered, and at the port of entry, they got actually matched with the husband's H1, which is until 2026. Maybe he got an extension or something. Then the H4 is valid until 26, but the H4 EAD expires in 2025, and you filed for an extension. Then you're allowed to continue working because the underlying H4 is still valid. So
Oh,
always making sure the H4 is valid, then the H4 EAD receipt will allow you to continue work. But otherwise, if the H4 is not valid, then you cannot work.
oh, okay. Praveen, I have one last question. Okay. So, in terms of legal insurance, like our company provides some insurance for the legal. Okay. So, do you accept those insurances?
No, we don't take any legal plans. Again, that becomes more complex for the firm to actually implement and do it. And we are pretty accessible and very affordable.
Okay.
So that's not something which will actually really discourage you. And I hear sometimes when I'm with my peers or something, then they compare and say, how come you are charging this? Right? We are pretty
Oh,
affordable,
okay.
very reachable. So
Good
no,
to know.
we don't accept insurance to answer this.
Okay.
So at this juncture, again, like I want to say, I want to share with all of you. Please email to Praveen@bizlegalservices.com. He has a lightning speed of reply. He will provide you the reply and help you as much as possible. Also, there is a phone contact number 847-995-1515, and you can always go to the website bizlegalservices.com. Praveen, I really appreciate on behalf of Sangam. I want to appreciate your time. I know that like it's a very widely discussed topic which you are dealing. It is not possible to give answer of all the questions in 1 hour or 1.5 hour. But I thank you for your patience, and definitely people who has question or whose question could not be answered, or who could not
No,
reach out, they will
I think
contact you.
we don't have any question in our chat box. We already discussed all questions,
Very good.
whatever you're asking.
Very nice. Yeah. Again, thank you. Thank you, the Bengali Association of Kansas, Sangam. Then it's a community service together. As people, we have to share knowledge, support each other in this journey. Again, whenever there are challenges, and this time it's more challenging in immigration. So obviously, we are all coming together to help each other and spread whatever the knowledge that we all have. With that intention, then definitely whatever help I can do as a member of the community, then I'm always willing. Then just remember, take right advices, and then make sure that you don't jeopardize your immigration status. There might be good days coming, especially for employment-based immigration. Just hope, my opinion.
Thank you, Praveen, for your expertise and dedication to helping individuals navigate to immigration matters are truly appreciated. So a big thank to all of our organizer and attendees for making a nice and great talk.
Yes.
Thank you, everyone.
Yeah.
Thank you.